Universitas PGRI Semarang is located in the culturally strong Semarang City, Central Java Province, Indonesia. With these features, Semarang is a potential place for students to develop themselves. The spirit that drives Universitas PGRI Semarang is nationalism and religiosity. Nationalism is the spirit to unite the nation in the midst of culture differences. We have 7 faculties consist of Faculty of Education. This faculty is the oldest faculty at our campus with the largest number of students. It has 3 study programs: the Guidance and Counseling Study Program, Elementary School Teacher Education, and Early Childhood Development Teacher Education. Faculty of Social Science and Sports Education. There are several points that become our focus in this faculty. First, the value of humanism as national identity. Second, physical health as a support for quality education. Third, the understanding of economic values as a pillar of human civilization. This faculty has 3 study programs: Pancasila and Citizenship Civil Education, Physical and Recreational Education, and Economic Education. Faculty of Language and Arts. This faculty provides education to generate language and art educators with pedagogical personnel, social and professional competence and competitive abilities in dealing with the current age development in order to develop themselves into professionals such as translator, newscasters, or journalists by making use of their language and artistic skills. This faculty has 3 study programs: Indonesian Language and Literature Education, English Education, Regional Language and Literature. Faculty of Mathematics, Science, and Information Technology Education. This faculty has study programs of Mathematics Education, Biology Education, Physics Education, and Information Technology Education. The vision of this faculty is to be an excellent and distinguished faculty of Mathematics, Natural Science, and Information Technology Education by 2025. Faculty of Engineering and Informatics. Established on April 17, 2014, this faculty has 6 study programs, namely Architecture, Mechanical Engineering, Civil Engineering, Electrical Engineering, Informatics, and Food Technology. Faculty of Economic and Business. This faculty has a mission to be a faculty of economics and business that excels in the field of digital-based creative economics and business with a distinctive identity. Faculty of Law. The Faculty of Law of University of PGRI Semarang is committed to develop legal knowledge, and this is done, among others, by organizing seminars, discussions, comparative studies, and field experience practices. In order to support the teaching and learning activities, we have 4 complexes of campuses. Campus 1, located at Jalan Dr. Cipto, Jalan Lontar. This campus consists of representative and modern buildings for teaching and learning activities. This campus consists of central building, main building, student activity center, library, graduate program building, as well as a representative auditorium meeting hall for national class concerts and international seminars. Campus 2, located at Jalan Sriwijaya. This campus has a hotel available for both students and public in general, as well as a large meeting room for teacher professional training programs and various other large-scale meetings. Campus 3, located at Jalan Bendan Duo. This campus has a building for students' practices, especially mechanical and electrical engineering department students. This campus supports various activities to increase electrical, mechanical, and architecture skills. Campus 4, located at Jalan Gajah. This campus has a teaching learning building complex and sports centers including basketball, badminton, futsal, and other athletic sports activities. This campus also has a dormitory building provided for students, as well as a high school laboratory school, which was established by the Universitas PGRI Semarang. Why do you have to choose UGRIS as a place to study? We realize the importance of international relations to connect the discourse currently developing in the international world. This is where we establish a collaboration to open up opportunities for career later through students and lecture exchanges, credit transfer and double degree program, joint internship and research, and publication with our reputable university partners. We believe that in our fast-paced and competitive world, there are basic competencies every young generation has to possess, namely excellence and distinction. Excellence in either emotional and spiritual intelligence and the ability to retain the personality as a cultured human being. Please join UGRIS. Universitas PGRI Semarang is located in the culturally strong Semarang City, Central Java Province, Indonesia. With these features, Semarang is a potential place for students to develop themselves. The spirit that drives Universitas PGRI Semarang is nationalism and religiosity. Nationalism is the spirit to unite the nation in the midst of cultural differences. We have 7 faculties consist of Faculty of Education. This faculty is the oldest faculty at our campus with the largest number of students. It has 3 study programs: the Guidance and Counseling Study Program, Elementary School Teacher Education, and Early Childhood Development Teacher Education. Faculty of Social Science and Sports Education. There are several points that become our focus in this faculty. First, the value of humanism as national identity. Second, physical health as a support for quality education. Third, the understanding of economic values as a pillar of human civilization. This faculty has 3 study programs: Pancasila and Citizenship Civil Education, Physical and Recreational Education, and Economic Education. Faculty of Language and Arts. This faculty provides education to generate language and art educators with pedagogical personnel, social and professional competence and competitive abilities in dealing with the current age development in order to develop themselves into professionals such as translator, newscasters, or journalists by making use of their language and artistic skills. This faculty has 3 study programs: Indonesian Language and Literature Education, English Education, Regional Language and Literature Education, Javanese Language. Faculty of Mathematics, Science, and Information Technology Education. This faculty has study programs of mathematics education, biology education, physics education, and information technology education. The vision of this faculty is to be an excellent and distinguished faculty of mathematics, natural science, and information technology education by 2025. Faculty of Engineering and Informatics. Established on April 17, 2014, this faculty has 6 study programs, namely Architecture, Mechanical Engineering, Civil Engineering, Electrical Engineering, Informatics, and Food Technology. Faculty of Economic and Business. This faculty has a mission to be a faculty of economics and business that excels in the field of digital-based, creative economics and business with a distinctive identity. Faculty of Law. The Faculty of Law of University of PGRI Semarang is committed to develop legal knowledge, and this is done, among others, by organizing seminars, discussions, comparative studies, and field experience practices. In order to support the teaching and learning activities, we have 4 complexes of campuses. Campus 1, located at Jalan Dr. Cipto, Jalan Lontar. This campus consists of representative and modern buildings for teaching and learning activities. This campus consists of central building, main building, student activity center, library, graduate program building, as well as a representative auditorium meeting hall for national class concerts and international seminars. Campus 2, located at Jalan Sriwijaya. This campus has a hotel available for both students and public in general, as well as a large meeting room for teacher professional training programs and various other large-scale meetings. Campus 3, located at Jalan Bendan Duo. This campus has a building for students' practices, especially mechanical and electrical engineering department students. This campus supports various activities to increase electrical, mechanical, and architecture skills. Campus 4, located at Jalan Gajah. This campus has a teaching learning building complex and sports centers including basketball, badminton, futsal, and other athletic sports activities. This campus also has a dormitory building provided for students, as well as a high school laboratory school, which was established by the Universitas PGRI Semarang. Why do you have to choose UGRIS as a place to study? We realize the importance of international relation to connect the discourse currently developing in the international world. This is where we establish a collaboration to open up opportunities for career later through students and lecture exchanges, credit transfer and double degree program, joint internship and research, and publication with our reputable university partners. We believe that in our fast-paced and competitive world, there are basic competencies every young generation has to possess, namely excellence and distinction. Excellence in either emotional and spiritual intelligence and the ability to retain the personality as a cultured human being. Please join UGRIS.
Nadia, are you there? Kalam? Kalam, are you there? Hello. Acha. Okay, okay, right. Ah.
Universitas PGRI Semarang is located in the culturally strong Semarang City, Central Java Province, Indonesia. With these features, Semarang is a potential place for students to develop themselves. The spirit that drives Universitas PGRI Semarang is nationalism and religiosity. Nationalism is the spirit to unite the nation in the midst of culture differences. We have 7 faculties consist of Faculty of Education. This faculty is the oldest faculty at our campus with the largest number of students. It has 3 study programs: the Guidance and Counseling Study Program, Elementary School Teacher Education, and Early Childhood Development Teacher Education. Faculty of Social Science and Sports Education. There are several points that become our focus in this faculty. First, the value of humanism as national identity. Second, physical health as a support for quality education. Third, the understanding of economic values as a pillar of human civilization. This faculty has 3 study programs: Pancasila and Citizenship Civil Education, Physical and Recreational Education, and Economic Education. Faculty of Language and Arts. This faculty provides education to generate language and art educators with pedagogical personnel, social and professional competence and competitive abilities in dealing with the current age development in order to develop themselves into professionals such as translator, newscasters, or journalists by making use of their language and artistic skills. This faculty has 3 study programs: Indonesian Language and Literature Education, English Education, Regional Language and Literature Education, Javanese Language. Faculty of
Hi, Kalam. All good. Your
Can you
mic is
hear me?
mute. Yeah, all good.
Yeah. Thank you very much, Michael. Sorry, got a
Yes,
bit
Kalam.
late.
Thank you so much. Yeah.
Yeah.
Hope you are doing
Wow.
good. Everything is good at your end.
Yeah, everything's good. Everything's fine.
Yeah.
It's been so long since we last meet. How are you in India?
Yeah, all good. It's raining outside. So
Oh,
The weather is cool. Yeah,
Yeah. In here, for the first time, it's been a little bit cold here.
cool here. Ah.
Yeah.
All right. Mm.
Heard that Yvonne is coming there. Have
Yeah.
you seen her?
No, I haven't seen her. Actually, I just went to my
Oh.
hometown. So only the last
Yeah.
week I was back. So probably I'll meet her. I'll see.
Yeah. Yeah. It's a shame I can't go there because I'm studying for my doctorate.
Yes, that's right.
Yeah. Okay. So is Miss Nadia here? Miss
Mhm.
Nadia?
I think she's there. Yeah.
Yeah. We can just wait a bit. So how's the guys in Jindal? Amin?
Yeah, it is as usual. You have seen the things, right? They are somewhere in an isolated place, unlike your university. I have seen the video. It is
Yeah.
situated in the center of the city, so you have access to everything.
Oh,
Uh, but here, you know that, right? It's only
yeah.
we are relying on only Blinkit, no other things.
Yeah. Everything is just blinking, just like
Yes,
us in Gojek.
yes. So, how is the business going on? All good?
Yeah, fine,
Fine,
fine.
fine.
I really want to go there to India again, but yeah,
Uh,
maybe next
yeah,
time.
next time, yeah.
Yeah. Okay, Miss Nadia is here.
Mm.
Miss Nadia, maybe you can start. Okay, so uh, the committee just give it to me to just start the series. So, Mr. Michael Falan. So this is the lecture series where we just start the lecture. So first, thank you very much, Dr. Michael Falan, for attending this lecture series. And this is uh, my students. Currently, there is around 50 students here, but more will follows. And let me start by saying good morning, everyone. Hello, dear participants. Good morning. Selamat
They,
pagi.
they are in the exile mode.
Yeah, selamat pagi, everyone. Okay, okay. So today in this great morning, so we are about to start the great event of the lecturer series with uh, Michael Falan, PhD, about the court from courtroom to communities restorative justice in Indian and Indonesian law. Where the speaker today is Michael Falan, PhD, and our second speaker is Nadia Latifah Nugrahini as a LLM. So in this morning, the first speaker will be Dr. Michael Falan, where he will present his paper. So let me tell you a bit about Dr. Michael Falan. He is a associate professor in criminology in Jindal Global Law School of OP Jindal Global University in Narela, Sonipat, Haryana, India. So he is my best friend, right?
Yes, yes,
Okay,
yes.
where he will present his paper of his concern in criminology. So without further ado, Dr. Michael Falan, please, your time is yours.
Yeah, Thank you, Galang. I think I'll be able to share the screen, right?
Oh yeah, Indah, maybe you can just give the permission to Mr. Michael Fallon, Dr. Michael
Yeah.
Fallon, to share his screen.
Yeah. Okay.
You can now.
Yes. I think.
Okay.
Am I audible? So my screen is
Yeah.
visible?
Okay. Yes, the screen is in. Everybody can see your screen now. Okay.
So, how long I have to present, Galang?
You have exactly 45 minutes.
45 minutes, right?
Yes.
Okay. All right.
Thank you very much.
7:50.
Okay.
Okay. All right. Yes. All right. So very good morning. Good morning to everyone. Can I get at least one good morning from the student side? At least one. All right. Thank you
Good
so much, guys. So
morning,
you are awake.
Naila.
And I know that it is having a continuous lecture, like online lecture, people from different countries, they come, they'll just talk. It's, I think you are graduates, right?
Yes,
Graduates, right?
everyone.
Yes. Yeah. So I know the technically the mentality of the graduates because I'm teaching graduates, and when I was doing my graduate, I know how much important I gave to sessions like this. So I just want you guys to just stay with me for 35 to 40 minutes. So this is something quite, I hope it will be a little bit interesting, and this has more scope, like particularly like very recently we have been, like in the last couple of decades, we are almost talking about restorative justice and all those things. And but like in unlike Western countries, in the South Asian countries, it is not been materialized, right? So I think if some of you, if you have something to do with this particular topic, restorative justice, this is for you guys. So just listen something which you are thinking, why not we can have something which is alternative to imprisonment. So if you have that option, if you are thinking of something like that, like, okay, why can't we have something like non-imprisonment punishment or non-imprisonment method of dealing with the people, and then restorative justice can be the best option. So that's what we are going to see. I know that we do have a different legal system around the world, like a different system based on religious belief, based on the cultural values, and the based on like the democracy. So like a political system. So we do have a system, but throughout the world, we don't have a uniform system. Like we don't have a uniform civil law or a uniform criminal law, or even though UN has many things to say, they do have so many things, but still, when it comes to implementation, it is subject to that particular country, how much effort they put, and their adaptability and acceptability that matters, right? So with this small intro, let's just go through this session. Right. Anyway, I'm Michael. I did my PhD in criminology, and I joined in Jindal in 2023, and now I have been promoted as an associate professor of criminology from this year onwards. So this is my email ID in case if you need any assistance in helping you guys with the research project or any of the guidance or anything else, you can just ping me with this email ID. I'm happy to help you. Right. So before we go into that, I'll just take you guys through some of the major components of any criminal justice system. What is a process? This process remains same throughout the entire country, throughout the entire world, right? So once the case is just getting into the criminal justice system, what is the process? The occurrence of incidents, then filing of FIR. It is there in India, but maybe in your country you will have something like a report. Like once the case is once the offense is committed, it's been reported to the police, and the police will file the first information report, and then the police will carry out the initial police investigation. Then they will file the charge sheet, that will be the final report, and the trial will take place in the court, and then the disposal. When it comes to the disposal, we have two things: either convicted or acquitted. In some scenario, there is something called a quashed. I mean, the police have filed a wrong case against me, so the case should be quashed, right? No acquitted, no convicted. If it is convicted, what are the type of punishment which is generally being given throughout the world? Fine, that maybe sometimes fine if it is a small offense, minor offense. Admonition, like they just forgive and say, okay, don't do it again. And then we have imprisonment, which include short, long, and life imprisonment. Short-term imprisonment, sometimes 6 months, up to 3 years, we call it as a short term. Long term is 3 to 10 years or 14 years. And some countries like states, they have 50 years, 130 years, 150 years imprisonment, right? So those things can be long and the life. And then, of course, we do have a capital punishment. In India, like we give capital punishment only to the rarest of the rare cases, not the all cases. And then we do have something called a probation. So probation is something like
Michael,
you know,
sorry
yes.
if I had to pause for a bit, but your screen is, I think you pause your screen. We can't see your slide. Maybe you can just, apa?
Is it?
Yeah, see, Michael Van has paused screen sharing. We can see your screen.
Okay. Okay. Is it visible now?
Not yet, I think. How about the others? Okay. Everybody can see your screen. Maybe you can just exit and then enter again.
It must be visible now.
Still not yet. Ya kan? Coba di ini adminnya. Adminnya dikasih ke ini aja. Maybe wait a minute. Let my students check out your okay. It should be.
Yeah, I'm giving share.
Please wait a moment, Michael. Sorry for the inconvenience.
No problem.
Wait.
Sorry, Mikhail.
Yeah,
Would
no
you like
problem.
to send your PPT to me?
Okay.
Through WhatsApp, and I will provide here.
Okay.
Yeah.
No problems. Just okay, so yeah, advanced. Even now it's same.
Yeah, still paused screen sharing. Maybe you can just press the play button in the green bar on the top.
Yeah.
I think that's not the one.
No, it's not working, right?
How about this? Maybe you can just send the slide to my students, to me, so I can just share this slide.
Yes, coming. This screen is just passed. Why it is passed? Okay, 1 minute.
Okay.
Just give me a minute. Let me just.
Okay, it's okay, fine. See?
Let's just try again.
I don't think this is it.
Yes.
Nah, yes, you can do. Okay.
All right.
Okay. Yes, we can see it
All
now.
right.
Thank you.
All right. All right. Thank you.
Okay. Okay.
Right. So as I said, like we do have a different punishment, including imprisonment, long term, short term. Then the probation. Probation is something like country like India. It has been given like if you are particularly if you are a first time offender and there is no major charges against you, and the punishment can be up to 2 years of imprisonment. In that is the case, instead of sending you to the prison, you will be under probation, right? Someone will be overseeing you, right? So that in that way we are avoiding the personal contact with the criminals behind the bars, so they don't learn the criminal behavior and they don't become a hardcore criminal, and they are getting a lifeline of living the space where the space uh, uh, where they have lived before occurrence of the offense. So there is a probation, and then followed by that we do have a community service, right? So these are some of the uh, some of the outcome of any criminal cases in India. Now let's see. So now the process and the punishment. Who are the stakeholders? Who are the stakeholders of any crime? So there will be 3 to 4 people. When it comes to the elements, number one, victim, offenders. We always think about these 2 people, victim, offender, and the stakeholders. So stakeholders including police, correction, and judiciary, right? So only these 3 people comes in our mind whenever we talk about crime. For example, our house, if there is some crime taken place near our house, right? So we don't know that person, or we may know the person, but we never try to intervene, right? So it is up to them. Whoever the offender, the police will come and they will do inquiry, they will arrest people, they will do all those things. So with that, the case will go parallelly. But what about the community? Right? What about the community? Like, for example, you are the graduates, like, if there is something, somebody is making derogative statement, or somebody is committing eve teasing, or some leverage, some leaving some sexual comment when you are walking on the street. If that person is not being treated or corrected by the system, being a woman, you feel afraid to go out, right? So if a crime has taken place, it doesn't affect only one victim, but the entire community, right? So that's how in restorative justice, it's an inclusive justice program, which the community also takes place. The community also take responsibility. So when it comes to the elements of crime, it includes the victim, the offenders, and the community members, and also the stakeholders. So stakeholders in the sense, right? I mean, the victim, I mean, the police, judiciary, and the other people. So you all know very well who is a victim. Every country have a different type of definition for the victim, right? So some countries say, some of the countries, like, okay, if a person has been victimized, then what will happen? The person will remain be treated as a victim. But what if the offender is not being get caught by the police or by the system, right? So what will happen to the victim, right? So a woman is traveling in a train and she's being sexually molested by a group of 3 to 4 members. She's going to the police and complaining. Unfortunately, the train doesn't have a CCTV camera, or the station doesn't have a CCTV camera. There is no evidence. Then who did that? What if the police is unable to crack the criminals? There, the definition comes. So the UN Declaration, the United Nations Declaration of Rights of the Victims of Crime and Abuse of Power, 1985, which clearly define who is a victim. this is applicable throughout the world. It says a person who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through act or omission that are in the violation of criminal laws operative within the member state, including those laws, all these things. And the declaration also says whether the accused person is being apprehended, caught, or apprehended, or prosecuted, or even convicted, a victim remain be a victim. Right. So that you have to keep in mind. No matter whether the accused is get caught or not, a victimization has taken place, and we have a victim now. So now we have a victim. What is the impact of victimization? Right. What are the impacts of victimization? So we do have, in broad term, we can keep it in a three: physical, psychological, and financial. Right. Even the verbal, everything that falls under psychological, everything has a psychological impact. So I'm just keeping it into three: physical, psychological, and financial. So these are the three way where a victim will get the impact of victimization. It can be physical injury, it can be a mental trauma, it can be humiliation, it can be somebody might put you down before people, and you feel like you have completely molested, or you lost $1,000, $10,000, or your wallet is being pickpocketed, you lost your jewelry, your passport, whatever, it can be anything. Still, it is an impact. Now let's see. Now you know who is a victim, what is the process, and what are the impact of victimization. Now let's see the role of victims in the CJS, where the victim stands. So when we try to trace the genesis of the role of victims, we have a different period: golden period of victims, victims' rights movements, the birth of adversarial system, offenders' rights movement, and the dark period of victims. So when we say the golden period of victims, it's very clear. It says golden period. That means whenever a victimization takes place, the victims had a voice to express how did they feel and what kind of punishment can be given to the offender. So there was a time before 15th century, even before 15th century, whenever there is a crime taken place, the judge or the judiciary will ask for an opinion from the victim. Okay, tell me what kind of punishment should be given to this guy. You have to say, because you have to be satisfied. What are the laws? So how we can repay those laws? So in those times, victims were given opportunity to express their emotional and the physically how much they suffered and what they expect from the process. So that period was considered as a golden period of victims. Followed by, there are so many victims' rights movements were taken place in the United States and some of the European countries where people have more concerned about the victims. And then it comes the adversarial system. So like throughout the world, majority of the countries, like whoever countries which were colonized by the British people, all those countries still have an adversarial system. So what do you mean by adversarial system? Only in the adversarial system, we have somebody called advocates, lawyers, somebody who represent the victim, somebody who represent the offender, and there will be a jury, a judge. So what happens? In the adversarial system, the victim is being completely blocked, right? So the role of victim is completely blocked, and the role of offender is also completely blocked, technically. So who are the players now? The judge, the defense counsel, and the prosecutors. That means the judge, the lawyers who represent the victims, and the lawyers who represent the offenders. But how did they justify this system? So there they started to talk about something like, if a crime takes place, for example, somebody is getting victimized. So it is that's why we call it as a social contract. Anyone knows about social contract principle? Anybody? Anybody who have a little bit knowledge about social contract principle? Anybody? Social contract.
Okay. Since they don't know much yet about this, maybe you can just explain further, Michael, so that they understand more.
All right. So I think my screen is visible, right?
Yeah, still visible.
Yes, right. Thank you. So the social contract principle is very simple. Let me ask you a small question. For example, if your Professor Galan is just coming to the class and he is just picking up a student and he's just like that, he's slapping them, right? He just slapped them. He just slapped you. So do you have a right to retaliate? Yes or no? Do you have a right to retaliate? Any answers? Or you don't know about me, forget about your professor. I happened to come to Indonesia. I'm just seeing some of you. Suddenly
Yeah.
I got angry. We had an argument and I just beaten one of you, or you just beaten me up, either way. So do we have a right to retaliate? Any response? Do we have a right to retaliate? I mean, can you take revenge? Because I have beaten you, or you have beaten me. Do I have a right to retaliate? Yes or no? Any one response? Yes or no?
Okay, come on in there.
Yes or no? If somebody beats you for no reason, do you have a right to retaliate? Yes or no? Yes or no? You can say no or yes. I don't ask you why you say no, why you say yes. Just say yes or no.
Okay, maybe I can just translate in Indonesian so that others can understand. How about
Yeah.
it, Michael? Okay,
Yeah,
so
that's what.
yeah, Indah. Everyone. So jadi Prof Michael ini apa Dr. Pak Michael ini bilang seperti ini. Kalau misalnya kamu ada di tengah jalan tiba-tiba ada orang yang meninju kamu, kamu ini bisa nggak punya hak untuk melakukan serangan balik? Ayo, everyone.
I think they are falling asleep
Are
still.
they shy or something?
Okay, I'll go ahead, no problem. So in the birth of adversarial system, what happens is like if something crime happens, the state take responsibility. Okay, he or she is my citizen. I failed to protect him. So I take cognizance, right? At the same time, I will also punish the offender, right? So that is how the adversarial system came. So the one who represents the victim will be the advocate nominated by the government, right? And the offender has to, hire their own advocates, or sometimes through free legal aid services, they will also get their advocates, right? So that's how it happened. So if the lawyer who represent the victim have more point, then the case will be in the favor of the victim. If the offender have more points, then the victory goes to the offender. Right. So that is what the adversarial system is doing. So whoever has a merit, the judgment will be in the favor of the merit, whereas they never bother the victim is being victimized. Right. And then many people have started talking about the rights of the offenders. Like all the prisons were overcrowding, offenders were treated like as slaves, like, they were treated as a sinners, and they were killed, they were tortured. Women and men were put in the same prison, overcrowding. Many things have happened. So in those momentum, does give a momentum for the people who fought for the rights of the offenders. So the victims were slowly started disappearing from the system. And now we are in the period of a dark period of victims, where the victims have no role at all. So through the practice of restorative justice, we are slowly bringing back the victim to the system, like how it was in the golden period, right? So what are the rights of the victims? Of course, the victims have a right to fair trial, right to be present, right to be heard, and right to restitution, right to compensation, and the right to privacy, more importantly. So these are some of the rights of the victims. Now, what are the approach of CJS? How the justice system approaching a criminal case? Earlier, it was like a retribution. Even now, we do have the same system of retribution. Retribution in the sense, eye for an eye, tooth for a tooth. If I steal 10 rupees, I have to pay back 15 rupees or 20 rupees, right? If I kill somebody, I should be get killed, right? So that is a retributive approach. And then there is something called reformation. So in the reformation, we have, we try to reform the criminals and then rehabilitating the criminals. And now rehabilitation of criminals as well as the victims. And now we have something called restoration. So what do you mean by restoration? So restoration in the sense, it's very simple. If you just look back my house, sometimes the paint is not good, right? So I just want to restore its early beauty. So I just have to repaint it again and try to bring it back to the time when I occupied this house. Right now it has been 3 years, right? So this is called restoration, right? Just bring back the actual situation where before the occurrence of the crime, right? So how the victim was, right? Sometimes in some of the cases, the victims, like particularly for the sexual offenses are concerned, the girls used to go out, come back anytime, they just enjoy their life. But the moment when they get victimized, there the problem comes, right? Then they don't even talk to people. They stop, stop believing people, trusting people, trust issue, and so many things, right? So through restorative justice, we will try to bring back to the original, bring back to the previous situation of the victim, not exactly the same, but at least the nearest place, right? See, I can just give you a simple example, right? So I have this sanitizer bottle. I'm just placing it in a place, and I'm just taking it out. If you ask me, sir, can you place the same bottle again in the same place where you kept before? It is impossible. At least there will be minor difference, right? At least 1 millimeter, right? 1 micromillimeter difference will be there. And that is what the restorative justice will do, right? Of course, we cannot, it's all about healing, right? So, what do you mean by restorative justice? So, Howard Seger, he is the father of restorative justice, right? He's the one who started talking more about restorative justice, how it has been defined. So, it is usually we say crime is something, a violation of the people and relationship. I mean, crime is not something which is committed against the state. It is something committed within our relationship. Like I have a good relationship with Galang, right? Maybe we may not know each other sometimes, if I happen to visit Indonesia, right? He's my good friend, right? So we happen to meet each other, greet each other, we spend time together. So if we had some issue, that means there is a problem with our relationship. If we had some issue, after some time, I cannot talk to him like before, or he cannot talk to me like before, because the wound still be there. And that's how the place of restorative justice is to heal the wound, taking responsibility, right? So particularly, and it creates obligations to make things right. Okay, my relationship with Galang is not good at time. I should make it right. So the process involves the victim, offender, and the community. And the purpose is to promote repair, reconciliation, and reassurance. Right? Repair, reconciliation, and reassurance. That means you have to repair the relationship and you have to reconciliation. That means all your wounds and everything should go away. Right? And then reassurance. Make sure that you are not committing the same crime again between you two. Right? So that is the sole purpose of restorative justice. So how a crime is being defined in the restorative lens, right? It's a crime defined by harm to people and relationship, and the people and relationship as a victims. Victims and offenders seen as a primary parties. They are not one-to-one opposite parties. And the victims' needs and rights are central. Wounds of offenders also important. And offense should be understand from the cultural aspects. It's not about, okay, Michael has committed a crime. What made Michael to commit the crime? What is the wound Michael has? Right? So why he reacted in that way? So the wounds of Michael, he is an offender. It should also be healed. At the same time, if Galang is a victim, and his wound also should be healed, and both our relationship should be, it should bring back. It should be put on the track again. Right? So that is the sole purpose of restorative justice. So what is the difference between the retributive and the restorative? In the retributive justice, a crime defined as a violation of the state, focus on establishing blame or to prove the mens rea, or the guilt intention, and the adversarial relationship and process. And justice is defined by it's through inflicting pain or punish the offender. But restorative justice, it is a violation of one person by another. Right? It's not about the state. State has no role. Right? It is, I have violated the privacy of Galang, or I have violated the human rights of Galang. Right? And it impacts the community as well. It has to be repaired. And the focus is on the problem solving. It's not about punishing or blaming somebody. It's all about solving the problem. And then it takes through dialogues and negotiations. Through dialogues, we'll speak, we reconcile, right? We'll make the offender to feel guilty, to take responsibility, and to how to make it right. Right? And then restitution and justice defined as a right relationship. Right? And why we need to have a restorative justice? We have a court, we have a judiciary, everything. But still, why we need a restorative justice? Number one, it focuses on healing, not just punishment. Right? If you happen to meet the people in the prison, after the victimization, they never had an opportunity to meet their victims. But somebody may feel very heat inside. They may think that I should owe an apology to the victim. I should go and ask apology, a simple apology, right? That make it right somehow, right? So it's all about the focus on healing. and it gives the victims a voice, and it promotes offenders' accountability. That means being an offender, I should take responsibility and I should be accountable of my action, what I have done, where it results in, right? And then it reduces reoffending recidivism, it restores community relationships, it works for both minor and serious offenses as well. It also aligns with the indigenous and cultural practices. It complements, not replaces the criminal justice system. So many people think that if restorative justice comes, then we don't need lawyers, we don't need advocates, we don't have a court. Everything will be taken care by the restorative justice system, the facilitator. Right? So it is not that, because we cannot apply restorative justice in all the cases. It's purely voluntary. It's purely, both the offender and the victim should agree to take part, and the community also should take part in some cases. So it will not replace the existing system, but it facilitates the existing system, right? So what are the restorative justice programs we have? Right. So we have a different restorative justice program. So what are the critical ingredients of this program? Right. So before that, I think I have swapped the slide. Yes. Okay. Okay, let's just see this. So what are the major ingredients of the restorative justice? First, an identifiable victim, voluntary participation by the victim, an offender who accepts responsibility, and non-coerced participation of the offender. We should not force the offender to take part, or we should not force the victim to take part in the dialogues, right? So these four are the major ingredients of restorative justice, right? And okay, this will come later, right? So, okay, right. So let's see this. What are the types of programs we do have? We have a different programs which includes victim offender mediation, conferencing, circle sentencing, peacemaking circles, reparative probation, and community board panels. So the most famous method is victim offender mediation. The victim offender mediation, in the sense, the victim, there will be a place, safe place, where both the victim and the offender will meet together one by one, opposite to opposite. There will be a facilitator, and he initiate dialogues. The victim have 1,000 questions to ask the offender. Why did you target me? What made you to do this? Do you see how much I'm suffering? Right? What is my situation? How you are going to pay back? Right? How you are going to make it right? Right? And the offender also can share their story, what made them to commit that crime, right? And how it can be make it right, how they can make it right, and in what way he can compensate the victim to make sure that he or she will not be a future threat to the victim. The victim can live life peacefully. With the help of the facilitator, it takes place. It doesn't reduce the sentence. For example, if it is a rape case, we cannot release the offender, but it heals the wounds of the victim. The victim will ask, I should ask one question with the offender. If he answer, I'm fine. Or they may need a direct apology from the offender, right? Eye to eye, right? It makes offender to feel guilty and responsibility as well. So they can spend rest of their time in the prison peacefully. Restorative justice is not to just just leave the people out of prison. No, it is the main purpose is healing, right? So, and they do have a conferencing. In conferencing, we have community people to involve. For example, some places where the juvenile crimes are high, right? So we cannot neglect the children of conflict with law as well, right? We have to include them. So with the big shots in the society, with the police people, with the probation officers, the correctional people, with the victim, everyone will sit together and sort out the issue. Okay, how can we make it right? Because it's not about individual problem, it is a community problem. So that is a conferencing. And the circle sentencing, people sit in the circle, both victim, offender, witness, and the community, and they will sort out the issue. And again, same peacemaking circles and the reparative and the probation. So how this program is being implemented, right? So first, the case is not coming to the attention of the criminal justice system. That directly goes to informal referrals through restorative justice. Sometimes it goes at the pre-charge. Pre-charge in the sense, so before the police charge the case, they will, if it is a minor offense, they will ask both the victim and offender. So would you guys would like to settle the issue outside the court through restorative justice process? It is possible. So they will refer it in that way. And then even after charging somebody, they will get to know, oh, there is some program called restorative justice. So through that, I can make it right. That is possible. And post-conviction and the post-sentence and also post-confinement as well, right? So restorative justice process is possible throughout the, right from occurrence to till the conviction. It's not about, oh, this is so early to apply restorative justice. No. In any stage of the case, you are free to apply restorative justice. So, the process of the restorative justice, when it comes to the process, they will make sure that the victims who agrees to be involved in the process can do safely and come out of it satisfied. Victim satisfaction is required. And then offenders understand how their action has affected the victim and other people, assume responsibility for the consequences of their action, and commit of making reparation. The offender should take responsibility, accountability for their action. And then flexible measures, right? For example, how you can repair the harm. Okay, for example, there is a murder victim, right? The offender is there. Now you cannot bring back the victim, right? But how you can solve the case? Maybe the offender can assure that, okay, I will take care of your kids' education. Whichever schools they want to study, I will pay for it because it is my mistake, my responsibility, right? In case I'll owe you an apology, my apologies. And financially, how can I support you, right? So these are some of the agreements they will come out of this process, right? Make sure the victim also agrees and the offender also agrees. It's not something through coercive process, right? And then offenders live up to their commitment to repair the harm. And offender will make sure that the offender is committed towards repairing the harm. It's not about, no, I don't want to pay for 10 years. I don't have money. I have other commitments. And they cannot stop the process in between, right? And then it will impact their spending time in the prison, right? And then the victim and the offender both understand the dynamics that led to the, and they will try to reintegrate into the community, right? The victim should not be isolated or the offender should not be isolated. Some people will say, oh, he's a prisoner, don't talk to him, right? We try to stigmatize them, right? But the restorative justice is try to avoid stigmatization. So the victim and the offender can live their life as like before, right? That should be the goal. Now let's come back to India. What is the crime rate in India? Crime rate per 1 lakh population. If you take 2000, it was 520, and now it is reduced to 445. That means every 1 lakh population, 450 people are getting victimized in one or other form of victimization. That's in India. Here is important. CSR versus FIR. In India, we have a system like if you are an affected party, they will not file a police complaint immediately. Whereas you can report the incident, but there is something called first information report. Once a police officer files the first information report, then he or she has to act swiftly on the complaint, arrest the accused, produce the accused before magistrate. All those processes should take place. But they'll take that as a complaint. First, they will take the complaint, and then they will investigate. If required, they will file FIR. Right. And that is what it reflected here, this number, 520 cases. But see the actual cases. For example, in one district, in the year 2024, how many complaints they have received? 67,115. Out of 67,000 cases, how many cases they registered? Only 830. The 5-year, it's a 5-year data. The 5 years, sorry, not 5-year, it's for 3-year data. In the 3-year, the police received 67,000 complaints, but they filed only about 830 FIRs. These 830 only reflects in the national level crime statistics. So people will say, oh, the crime rate is very less. But the actual number should be 70,000, right? You have seen that. It's about 67,000. So how the police used to settle the case? So we have some of the programs, the traditional program, like kind of a restorative justice program. We have a Nyaya Panchayat, the Panchayat level, a Sarpanch level. They'll deal with the minor criminal and the civil acts. Then we do have some program called Nari Adalat, the Naga Dialogues.
Sorry, Michael, just
Yes.
need to remind you that there is still 5 minutes left.
Sorry, Galang, I'm unable to hear your voice.
Yeah, just wanted to remind you that there is 5 minutes left.
Yes. I'll wind up now, right? So we do have a traditional setup which family and kinship counseling, joint family system, and the caste, community panchayat, village panchayat, and the social religious methods. And we do have a lok adalat, a plea bargaining, compensation, mediation, and admonition. So these are some of the restorative like related programs we have in India, but the actual restorative justice program, which includes victim offender mediation and the circling, and these things are it is happening, but in a different setup, in a different protocol, in a different mode. It's not been formally materialized. Right. So in police station, what are the RJ practices they do? The moment when they receive the complaint, they'll make sure it is cognizable or non-cognizable. So cognizable in the sense, serious crimes, murder, kidnap, serious crimes. Non-cognizable in the sense, small petty offenses. If it is a cognizable crime, they will make them to directly deal it with the court process. It has to be dealt only through the court. Sometimes at the police station level itself, they will try to settle the case if it is not that much serious crimes, right? So what are the methods they adopt? They do adopt victim offender mediation, conferencing, peacemaking circle, and restitution. So the police will act as a restorative justice facilitator. They'll bring the victim, they'll talk to the offender, and they bring all the people together in the police station, and amicably they will settle the issue. They'll make sure that they are not filing a criminal charge. So what is the advantage? Somebody who committed a crime, they get a lifeline. Because if they file a registered case against them, they cannot travel abroad, they cannot apply for a government job, right? And they have to go to jail, prisons. So in order to avoid that, this gives them an opportunity to make things right? So these are some of the restorative justice initiative which is being taken at the police station level, right? And what are the benefits of the state? What the state will get benefit out of it? Number one, reduce the cost of criminal justice. You have to file an FIR, lots of human resource, lots of paperwork, go to the court. Already courts are pending about 5+ crores of cases are pending in the court, right? So by adopting this method, you can reduce the cost to the justice system, reduce recidivism. You are giving one opportunity to the offender, increase victim satisfaction, promote social cohesion, eases courts and prison overload, right? So prison overload will be reduced, support youth rehabilitation, And these are some of the benefits. And what are the challenges? What are the challenges the by implementing the state will have? There's lack of legal framework, resistance from the traditional justice system. People will say, no, we will see in the court. We don't want to settle in the police station. We don't want to settle in the RJ process because sometimes it will be biased. You will be in the favor of the offender, right? And sometimes the public, the people are not aware. We can't apply RJ to all the cases, right? And inadequate training and skilled facilitators. Voluntary participation is another challenges. And of course, there is a risk of a re-victimization as well, funding, and the lack of evaluation data, like how the success rate, how to measure the success rate. So these are some of the challenges which can be easily mitigated when you try to apply restorative justice, right? So this is my recent paper which I published, which is about decoding of restorative justice practices, evidences from the Indian police station. And I'm happy to share the chapter with you. It's a book chapter and a very good book. So you can, if you have an access, you can see this book where I have I have spoken more about restorative justice in India, right, in a very uniform way, very unique way, right? So that's all, folks. So here is a question and answer session. If you have any doubt or concern, you can just ask a question. I'm happy to
Okay.
answer.
Wow. Okay. Thank you very much, Mr. Michael. It's really awesome. Yeah. So the time about the restorative justice is concerned both in Indonesia and in India because not only it can deliver a better justice for us, but it also can took care of the problem of the overcrowded prison. Okay, so for the next
Galang,
session, I think,
Galang,
yeah,
you can use the headset. You can use the headphone because your speaker
yeah,
has some
here,
noises. Yeah.
yeah, I'm using my headphones here. Maybe there's
Okay.
a
Some noise. Okay.
echo somewhere. Okay, uh, okay, thank you very much, Michael. So, Michael, sorry for the next session is will be Miss Nadia for for her session, and then there is a question and answer session after that. Is it okay with you?
Yeah. Yeah. Absolutely.
Okay. Yeah. Okay. Thank you very much, Michael. So the next session will be brought by Mrs. Nadia Latif-Anugrahini. She is the Secretary of the Faculty of Law, PGRI University of Semarang, and specialized in international law. So, Miss Nadia, how are you?
Hey, I'm fine.
Okay, Miss Nadia. Okay, so without further ado, the time is yours now.
Yeah, thank you so much. Good morning, everyone. My name is Nadia. I'm one of law lecturer in University of PGRI Semarang. I will say hello to the first speaker. Hello, Michael. Nice to see you. Perhaps Galang have see you in person directly, but we are nice to see you in virtually. Perhaps we can see you in person in Jindal Global Law School in one
Yeah.
day.
Yeah.
Yeah, we must visit
Cool.
India, right?
Yes.
Yeah.
And you have to visit Indonesia. Okay.
Yes. Yes.
Okay, thank you so much for your precious time anyway, Michael. And here I will present restorative justice in Indonesia. So before we have to know the restorative justice system in India and then the cases, the implementation as well. So here we can compare with the restorative justice system in Indonesia. Okay, wait. I will share my screen. Wait. Okay, wait a minute.
Is Nadia is there, Gala?
She's just sharing her screen. Maybe
Okay.
she needs a little
All right.
time.
All right. All right.
Yeah.
Yeah.
Okay, I'm so sorry because there is technical problems with my PPT. I don't know why it cannot be shared here, but I will tell to you how the restorative justice system in Indonesia. Guys, everyone, as we know, that Indonesia is a legal state founded on Pancasila with the national and governmental ethos organized around this idea. With the intention of preserving and advancing human dignity, the Indonesian state regards the law as the ultimate commander. Justice, legal clarity, and expediency are the three fundamental values of law that the ideal law enforcement system must be able to uphold. So, actually, it is difficult to achieve these fundamental ideals in harmony, both theoretically and practically. Sometimes achieving the values of justice and expediency means sacrificing the value of legal certainty. Value of justice and expediency could mean surrendering the value of legal certainty. So, the codification and unification of criminal procedural law in Indonesia through the Criminal Procedural Code has been going for around 4 decades since the enactment of Law Number 8 of 1981 concerning the Criminal Procedure Code. The law of evidence is part of the criminal procedural law. The main source of the law is Law Number 8 of 1981 concerning criminal procedure law, or KUHAP. We call it State Gazette of the Republic of Indonesia. Actually, the evidence system regulated in Article 182 of the Criminal Procedure Code. Various types of evidence are regulated in Article 1984 of the Criminal Procedural Code, and the strength evidence of regulated in Article 184 of the Criminal Procedural Code. So, actually, the Criminal Procedure Code regulates procedure rules in handling criminal cases, while providing legitimacy to suspect or defendants to defend their interests before law enforcement official. This explicitly recognizes their inherent human rights and protects them from arbitrary actions. So, the Criminal Procedural Code seeks to establish legal rules that try to free suspects or defendants and their families from misery and despair in the midst of an unfair law enforcement process. In accordance with the spirit of its mandate, suspect or defendant must be treated by adhering to human. So over time, the Criminal Procedural Code has revealed shortcoming and weakness in its implementation. So the Criminal Procedural Code is considered no longer in accordance with changes in the government system and legal development in society. So it needs to be reformed with a more responsive criminal procedural law. Note that the existence of two indicators that describe this condition. The first, as we know that the criminal code is still unable to meet the legal needs of society, especially in the practice of handling criminal cases, which are duty law enforcement official to resolve them properly and fairly. The second, legal developments and political changes accompanied by global economic, transportation, and technological advance also have a very huge impact on the meaning and substance of the criminal procedural code. So the weakness that is clearly visible in the criminal procedural code is that it gives broad authority to law enforcement official, especially the police and the prosecutors, without being accompanied by adequate monitoring and accountability mechanism. This is increase the potential for abuse and also corruption at the various types, starting from determining the suspect, terminating the investigation, terminating prosecution, to carrying out the execution. So the academic paper in the 2010 on COHAB outlines the rationale for the urgency of reforming the COHAB. So one of the basic reason for this is the economic aspect, which state that all article in the criminal procedure code refer to a justice system that is speedy, simple, and also low cost. So the introduction of a speedy justice system is implemented through mechanisms such as a filing case, through special channels, settlement outside of court, and filing cassation request to the Supreme Court through the High Court to reduce the workload of the Supreme Court. So one of the occasion, one of expert explained that the criminal justice system is a judicial network that involves material in a criminal law, formal criminal law, and also criminal implementing law. However, this institution needs to be understood in a social context. The overly formal nature of the system is only used solely to achieve legal certainty can have bad consequences by causing injustice. So, as we know, currently the criminal justice system in Indonesia applies retributive justice as its main principle. However, what is hoped for is restorative justice, where all parties involved in a criminal act work together to find solution to deal with the consequence in the future. Restorative justice is a model for resolving criminal cases that emphasize restoration for victims, perpetrators, and society as a whole. So restorative justice can be realized through several methods, such as mediation between victims and perpetrators, family group deliberation, and community services that focus on recovery for both victims and also perpetrators. The application of the principle of restorative justice depends on the legal system adopted by a country. If the legal system doesn't encourage the implementation of restorative justice, then this principle cannot be enforced. Therefore, the principle of restorative justice is an option in designing a country's legal system. Even though not all countries implement this restorative justice system, this doesn't mean that it is impossible to apply the principle of restorative justice to provide a justice, certainty, and legal benefits. Law enforcement in Indonesia is currently still facing various problems that need to be resolved, especially in criminal cases involving parties involved in society. So in the context of law enforcement in Indonesia, Law number 8 of 1981 concerning criminal procedure law plays an important role. This criminal procedural law refers to the formal implementation of the law. So the term of law enforcement can be associated with the imposition of crimes or the imposition of sanction as a concrete form of implementing the law. So related to this, there are three basic concepts in criminal law, namely unlawfulness, error, and then criminality. So law enforcement is not only related to formal aspect, but must also be based the regulation made. In making regulation, it is important that every regulation made has value that is beneficial to the society. So the concept of restorative justice involves perpetrators, victims, families, and other related parties in resolving criminal acts and their implication with a focus of restoring the original situation?
Yes, me.
Actually, the concept of restorative justice is in criminal law system in Indonesia. Restorative justice focuses the need of the victims and perpetrators in crime. So this principle can be applied cases that result in financial losses or cases of minor crimes. So the application of restorative justice in resolving criminal cases in Indonesia is not only limited to the formal and material criminal law provision. This concept prioritizes justice that involve perpetrators, also victims, and society that can be integrated manner. This can be reflected in law enforcement action to stop investigation, inquiries, or prosecution as part of the criminal justice system. So the model of implementing restorative justice in Indonesia criminal procedural law is based reforming the criminal justice system, which involves legal problem solving, and the reform adopts a new system such as bargaining or deferred prosecution agreement with the aim of realizing a more effective and efficient criminal justice process. So the application of restorative justice in a criminal law system in Indonesia can provide alternative case resolution that is fair and takes into account the interests of victims, perpetrators, and society as well. Okay, perhaps we can continue to question and answer. We discuss how actually the restorative justice in India studies and also in Indonesia. We have a fruitful discussion, guys. If you have any question, please you can raise your hand or introduce your name and then convey your question. Thank you. Perhaps I give to our moderator, Mr. Galang. Are you there?
Kalang is not there.
Okay, sorry.
And I will call Michael as well here.
Yeah, I'm here.
Yeah.
I'm here, Nadia.
Yeah, we discuss. We open question and answer, please.
Okay, so that's it, everyone, for the material given. And next is the question and answer session. So I allow the audience to please answer question. All right, everyone, is there any question?
Pak Galang,
Yes.
I have any question for Mr. Michael. Can I?
Yes.
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 Oh, okay. So it's
What's
about.
your name?
Oh, okay. I'm sorry. My name is Aisyah Dinda Ada, and I'm from Faculty of Law. I'm in semester 4 right now, and I wanna ask some question about the restorative justice in India. So, if I'm not wrong, at listening, restorative justice is about the process of returning something to original state or original condition. So my question is, how about some offender not really ability to restore what they do? Is that there's something punishment to them, or for example case the offender cannot the offender take a victim money, and then the offender cannot really ability to give back victim money. So is that there's a punishment or there's some penalty to organize it, or really about the healing? Thank you so much.
Yeah, it's a
Okay.
wonderful question. What if the offender is unable to meet the agreement? So most of the cases, it is being determined based on the offender's ability. Number one. Number two, not everyone is eligible to take part in the RJ process. It is purely voluntary, and it is somebody, when the offender gives commitment, the offender must be able to hold the commitment. If they fail so, then whatever the punishment which is been already allotted by the justice system, he has to undergo for the same. Right. So again, the case will be prosecuted in the court, even if it is middle. For example, 10 months you have to give compensation to the victim, but he gives only 3 to 4 months. Then he stops giving and he said, no, I have a different commitment. I cannot keep my commitments. Well, many excuses he can give. Right. So in that scenario, again, the court will intervene. The court has the power to intervene, and he or she can be put back to the prison. That is what the usual practice the Western countries they follow. But in India, of course, we don't have that formalized restorative justice system. But again, the same thing happens at the police station level, right? For example, there is I borrowed 5 lakh rupees from a person. At one point of time, I'm unable to pay it back, right? And I have a quarrel argument with the lender, and it became like a simple hurt case, right? From civil case to criminal case. So now how the police will deal with that, right? The police can file an FIR and they can arrest me or the other party. They can put them behind the bars, right? So if those cases, they will compromise, right? They will bring both the party and they will write a written agreement that I will pay this amount within this particular point of time. If I have beaten that person, I express apology, right? If I fail to do or keep the commitment, keep the promises, then the police will prosecute the case at the judiciary as per the due procedure. And that is what exactly will happen. I hope I answered your question.
Thank you so much, Mr. for the answer.
Yeah, thank you. Thank you.
Okay, awesome answer. Okay, so is there anyone? Maybe for Miss Nadia or for Mr. Michael Falan? Maybe two more?
Hello.
Yeah, Naila. Yes,
I
please.
have for Mr. Mike, Michael.
Yeah.
How
Michael.
does the Michael? How does the local community system, such as Panchayat Raj, affect the implementation of restorative solution? Thank you.
Yes. So when it comes to local panchayat, whatever the decision is being taken, it's binding. It's binding again, but most of the times these local panchayat decisions are biased. If you are powerful in that village, right? If you're powerful, you have more money, and the victim is somewhere from the poor family. So 99% it will be in the favor of the offender, not in the favor of the victim. So that is the reason why we don't call it as an actual restorative justice practice. In the formalized restorative justice practice, the entire procedure is completely different. But here, what we follow is like-minded or the restorative justice-like practices, right? So most of the times it is binding because the same person, the victim also have to stay in the same village. The offender also will be stay in the same village. So usually, they try to do it in a very good way to settle the issue. Sometimes there will be biased, and that is the one challenge we do face. But if those cases, if the victim feels that the victim is being targeted or is being the entire narrative is being set against the victim, and then the victim can seek the regular procedure. The victim can approach the court or the police to initiate the formal dialogues. But these are all some of the informal, not the formal one. I hope I responded. Naila?
Okay. Is that enough satisfactory, Naila?
Cukup, Pak. Thank you,
Okay, enough.
Mr. about the answer.
Okay, so yeah, enough, Michael. Maybe one more question. Anyone?
Excuse me, sir.
Yes. Raffi Azhar, the time is yours.
Yes.
Raffi.
Excuse me, my name is Ravi Azhar Izzuddin. I'm from semester 6. I want to ask to Mr. Michael, does the current application of restorative justice in India provide enough space for victims to actively participate in the case resolution process, or is it still dominated by the legal apparatus and perpetrators?
Yes, Rafi. That's why I'm saying most, not most, almost all the except Japan and most of these Asian countries, we don't have a materialized or the structured restorative justice program, right? So everything is being settled outside the court or in the police station in the presence of the police officer with both the party. They speak, they sort out the differences, and they will settle the issue. But there are issues where whenever, as I said, whenever the victim feel biased, of course the victim will be given opportunity to express themselves, how much impact it created. It doesn't mean that the police itself will take responsibility. In some of the cases, if the victim is from the very poor socioeconomic background and the victim's voice is, they don't have anyone to back them up, in those cases, the police officer will speak like, for example, if the victim may need a compensation of $1,000, for example, $1,000. But the police will say, no, we can't take $1,000. We just give you $100. So where the 100 and where the 1,000 is there, right? But if the victim also backed with some good lawyers, or the victim also have a good family, and then the victim can make it up to at least $750, right? But again, the police will take some money and they will give the remaining money to the victim, and these things are happening. But I'm not saying that it is 100% successful, and it is not 100% failure as well, because of the procedural lapse in the normal judiciary or the court. It will take minimum 2 years or 3 years to court procedure, which nobody want to spend their time in the court, right? So, for example, if you have a hearing is given in this particular date, if you are working somewhere, you have to take leave. For working professional, their casual leave is hardly 10 to 12 days per year, other than Saturday, Sundays, right? So Saturday, Sunday, court won't work. They won't function. So they cannot spend their entire leave just to spend time in the court, right? Sometimes when you go there, the offender will not come, the other parties will not come. Sometimes the prosecutor will not be available. Judge sometimes will be on leave, right? So people will try to settle the case at the station level itself to make sure they are not losing anything. They'll consider how long the procedure will take in the court. I'll better solve the case. So most of the times the victim has a voice, right? So rarely some cases they will try to suppress the victim. Yeah.
Okay. Thank you very much, Michael Fallon. Is that it? Is there any more question?
So I have one question for Nadia.
Okay, Nadia.
Yeah. Yeah. So Nadia, you
Okay,
were just
sorry.
talking something about restorative justice in Indonesia. Like, you said like it's completely a retributive approach. So how do you forecast the future scope of RJ in Indonesia? Restorative justice in Indonesia. How do you forecast what you can expect in the future? Maybe after 5 years or
What's
10
in the
years.
future of
Yeah, the government is somehow they are doing, they're thinking of implementing RJ related practice. So what is the possibilities?
Okay. Thank you so much. In Indonesia, in Indonesian cases, actually, I will explain to you that we have, what is it? Criminal justice system. This is litigation and non-litigation. And non-litigation, there are mediation and also negotiation, arbitration, and all that methods we call restorative justice. So actually, the restorative justice in Indonesia is still very have what is it? Still very have a big problems and a big homework to the restorative justice system. I mean, actually, if the society and also the victims and also the perpetrators and also the legal institute and all the stakeholder can be integrated in a one system. So I think the restorative justice system for the next future in Indonesia can be implemented well. Actually, the big problem is the literation for the society, the uh, solving problems, solving criminal problems in Indonesia is also related to jail, is also related to the courts, but actually not. We have a restorative justice system for the small problems, small criminal problems. We have a restorative justice system, but the literation for the society, they only know if the criminal is also jail. So I think in the future, the big hope is the literation for the society can be high. So the integration between stakeholder and also the society that introducing restorative justice system is can be implemented very well. I think the case in Indonesia like that, Michael.
All right. Thank you, Nadia.
So
Okay.
yeah.
Okay. Is that enough, Michael?
Yes.
Awesome. So I think that concludes for our this session of the lecturer series. Nadia, Miss Nadia, thank you very much. Michael,
Yeah,
we
thank you
thank
so
you very
much.
much for your knowledge given to us for the
Sorry, Mr. Galang, perhaps we have a photo session first.
Oh yes,
Yeah.
of course.
Everyone,
So
can you
Indah,
open the camera and then we have a photo session for the documentation. Thank you.
yes. Everyone, please turn on your camera. Kameranya dihidupkan, tolong.
Okay, I will count
Okay.
1, 2, 3. Cheers. 1, 2, 3 again. Wait a minute. Okay, then. Thank you, Mr. Galang. Thank you, Michael. Thank
Thank
you
you,
so
Galang.
much.
Thank you,
Michael,
Nadia.
thank you very much,
Thank you,
Michael.
guys. Yeah, all the best. Thank
Yeah.
you.
See you on the next occasion.
See
Thank you
you.
very
Yes.
much,
Bye-bye.
Michael.
Thank you so much,
Yes, yes.
guys.
Thank you. Thank you.
Yeah. So that concludes our session. Thank you very much, everyone. See you at the next time.